Gentlemen, in 2022, RBC released a report entitled 92 to 0, How Economic Reconciliation Can Power Canada's Climate Goals. The report noted that achieving net zero, and I quote, will rely heavily on vital sources of capital held by Indigenous nations, and RBC estimates Canada needs roughly $2 trillion in capital over the next 25 years, much of it from the Indigenous sources or unlocked by Indigenous partnerships, including ownership, end of quote. The report notes that the Indigenous lands hold vast resources essential to green energy systems, including 56% of advanced critical mineral projects. With the urgency of economic development, if the government looks at prioritizing some critical minerals projects involving Indigenous lands, can you please walk us through what the consultations and decision-making would look like with Bill C-5 compared to without it?
Well, I can certainly begin, Senator. One of our main concerns about the bill, and this has been echoed by the Indigenous groups that have come before you, is that there is no explicit reference to the free, prior, and informed consent of Indigenous nations to the types of projects that you mention. There may indeed be vast wealth stored in Indigenous lands, and Indigenous people may indeed wish to exploit that, but those decisions must be made with them, by them, and not over their heads. That's our clear position. There is, what we are concerned about, having looked at the bill, is that now, and to highlight your question about the differences between before and after, currently, getting to a possible yes is a process that happens during the environmental assessment, because that is when we understand what the real impacts are and the benefits to Indigenous nations. The environmental assessment is an essential element of the consultation process. This bill includes it. Environmental assessment still happens, but the outcome is preordained. There will always be a yes in any event of the EA, and that cannot be true consultation. Because if the answer is given before the debate occurs, then the debate has meant nothing, the consultation exercise has meant nothing. So we say the bill should be revised such that Indigenous nations always have a say in both the whether and the how.
And if I may just add, or, okay.
Good. You have another question, Senator Klyne? Go ahead.
Thank you. This gets back to a little bit to Senator Wilson's questions and back to some of your opening remarks. But Part 2 of Bill C-5 would allow Cabinet to exempt a national interest project from the application of Canada's environmental laws. For example, to name a few, Schedule 2 of the bill contemplates Cabinet making regulations to exempt projects from the Fisheries Act, the Migratory Birds Convention Act, the Canadian Environmental Protection Act, and the Species at Risk Act. Now, Canadians may have concerns about with such exemptions, and it could mean, for example, for fish habitat, migratory birds, toxic pollution entering the environment and communities, or protections for endangered species. Are you concerned that such expectations could harm the environment, wildlife, and people? And what advice would you offer to the senators in this chamber here?
Is that
for anybody?
For anyone?
I mean, I will just say that, yes, I'm concerned, and I think this is the tricky part about this bill, of course, is that I think, the government will say, well, we're not going to use it that way. But the power is there, and it will be sought. Like, someone will want, because their project will be cheaper if they don't have to worry about fish habitat, if they don't have to worry about migratory birds, if they don't have to worry about toxic substances. And so it'll be the case that this power, that proponents will seek to have this power exercised. And the question, I guess, is, why would if the government doesn't want to use it, then why would you give it to yourself? And not only then is it, like, in a sense that's maybe perhaps harmless because you say, well, the government will say no, but it will require bureaucracy it will require, that this new office that's going to be created to implement this bill, it will need a small army of bureaucrats to deal with all the requests to change or waive the standards that currently apply to projects. And so, I think myself and I think, as Mr. Ginsburg expressed in the community that he represents, close that gap, close that ability, just get on with it. We have standards. They're not particularly onerous anyway, frankly, so just keep the standards as they are, require the government to meet them, require proponents to meet them, and then move forward. Just move on, get it done, instead of, constantly relitigating this law or that law, whether it should apply or shouldn't apply.